Hi everyone, it's John Mitchell, and in today's video, we're going to look at dispute resolution processes. So, while it's preferable that everyone gets along and is happy with everything that's occurring within a business, that's not always the case. And so, workplace disputes can actually occur at any time. Now, this could be a dispute or disagreement between two employees, or it could be between the employees and their manager, or it could even be between the employees and the business overall. And these disputes can occur for a whole range of reasons. For example, it could be that it's during a negotiation of a new enterprise agreement, and both the business and employees are not really seeing eye to eye on what the new paying conditions should be. There could be issues around safety, or an employee may be disciplined and they feel that they've been dealt with unfairly. Maybe the employee feels that they haven't been treated with respect by a manager or another co-worker, or even it could even be a disagreement over the way that a business is implementing some of the wages and conditions that are in the agreement, and the employees are disputing the business is therefore not meeting their obligations. So whatever it's about, it's important that the dispute is taken seriously and that it's dealt with in a fair and consistent manner. So businesses, they should have a process in place for resolving disputes so that when they do arise, they can be rectified fairly, but also quickly, where everyone is shown respect so the employees can get back to being productive and achieving objectives. Now, before we get into the different processes in our study design, I want to address the concept of industrial action. So, industrial action is the measure or actions taken by employees or employers as a form of protest. And industrial action will sometimes take place during the negotiation of a new enterprise agreement, where the negotiations have broken down and the employees feel that the business is not really valuing their contribution to the business by offering improved wages or conditions that they really want in that new agreement. So they may take industrial action as a protest. And so some common forms of industrial action are strikes, where the employees actually withdrawing themselves from completing work for a period of time. There's a work to rule, which is where the employees only carry out the tasks that are in their job description and they don't go above and beyond, only doing the minimum that's required. There's work bans, which can be where the employees refuse to perform all of their duties. And then there's a lockout, which is the most common form of action taken by an employer, and is where they lock out the employees so that they're unable to attend work. And that's often in response to industrial action taken by the employees. Now, the days where employees and their unions could just take industrial action at any time with very few consequences, they're long gone. So now the employees, in order to take industrial action that's deemed legal, they need to apply to the Fair Work Commission. And if the Fair Work Commission approves the industrial action, then it's deemed to be what we call protected industrial action, and it is therefore lawful. So some of the things that the Fair Work Commission will look at before approving the action is firstly to ensure that the proposed action is actually supporting claims in relation to a new enterprise agreement, so over those wages and conditions, and that the action can only be taken after the previous enterprise agreement has actually passed its expiry date. And also, they need to ensure that both parties have genuinely tried to reach an agreement. So the employees can't begin a negotiation with their employer over a new enterprise agreement by coming in and going on strike straight away. For the action to be deemed protected, they need to have tried to reach an agreement first. And if they keep butting heads over certain issues in the new agreement, then they can take that action, or at least they can apply to take that action. And also, the employer has to be provided with notice that the action is going to be taken. However, if the Fair Work Commission has not approved the action, but the action is still taken, it is then deemed to be unprotected action and is therefore unlawful. And that means that damages can be sought. Now, it's important that businesses are able to resolve these disputes so that the employees can get back to being productive and working towards the achievement of objectives. And disputes do not create a real positive work environment, so resolving them can help create a much happier workplace. And depending on what the dispute is about, the first step is often for the disputing parties to discuss their concerns with each other, or possibly go through the process of negotiation. So, negotiation where the disputing parties discuss their issues on their own and then come to their own resolution. And that can help maintain relationships, which is really important. For example, let's say there's a dispute between two employees or between an employee and a manager. Maybe the employee is unhappy with how the manager or the other employee spoke to them at a meeting. And the first step in resolving that dispute could be for the two of them to sit down and discuss their concerns. And so maybe the manager apologizes for speaking to the employee with disrespect, and maybe the employee agrees that they shouldn't have really challenged the manager in front of everyone at the meeting. And hopefully, therefore, after that discussion, the dispute's resolved. Or it could be in a situation where there's a current enterprise agreement has expired and it's time to negotiate a new agreement. You've got the representatives of the employer on one side and the union representing the employees on the other. And the first step would be for the both parties to lodge what they want implemented in the agreement and then to begin negotiating between themselves with the aim of coming to an agreement. However, sometimes these discussions or negotiations break down and the disputing parties just can't come to their own resolution. So maybe the discussions turn into arguments and the dispute is just not getting resolved. And in those cases, often the next step is to go through the process of mediation. So, mediation is where an independent third party helps facilitate the conversation between the disputing parties with the aim of those disputing parties coming to their own agreement. That's important. They come to their own agreement. So, the independent third party can sometimes be someone from inside the business, or it could even be a mediator brought in from outside the business. For example, with our situation before, where there's a dispute between two employees or between an employee and a manager, could be agreed that the manager of the employees or the human resource manager, for example, is brought in to be the mediator. Or during the negotiation of a new enterprise agreement, maybe an external mediator is brought in. Now, it's important to note that the mediator does not offer any suggestions of a solution or make any demands on either of the disputing parties. They're just simply there to help facilitate the conversation. And one of the advantages of mediation is that the disputing parties are coming to their own resolution and therefore they're more likely to be accepting of the outcome. And it can also help maintain positive relationships because both sides are being heard and reaching their own agreement. And mediation is often cheaper than other forms of dispute resolution, such as arbitration, which we'll get to in a second. And the great benefit is that both parties have the opportunity to communicate without the other party constantly talking over them because the mediator is helping facilitate those conversations. However, with mediation, there is no guarantee that there will be a resolution. And if both parties come to a resolution as a result of the mediation process, then it's often not legally binding. And so once they come to this resolution, they may change their mind, or one party may change their mind later on, and therefore there's no resolution actually achieved. And it is voluntary. So while a time can be set up for mediation, it is not compulsory for anyone to turn up, which, if it happens, that can just simply delay resolution. And so, if things continue to break down, the disputing parties may decide that arbitration is the best way of getting a resolution. So, arbitration is where both parties put their case forward to an independent third party who then makes the final decision on the outcome. So, that may need to occur if the parties simply cannot come to their own agreement or own resolution. So, after considering both sides, the arbitrator will make a decision that is binding by law. And the Fair Work Commission is often called upon to be an arbitrator in these types of matters. Now, one of the benefits of arbitration is that there is a guaranteed outcome and it's quite an efficient process. So, with mediation, the process can be ongoing if the parties cannot come to a resolution. However, with arbitration, the decision is relatively quick. And it's also compulsory for the disputing parties to attend, and the decision is binding. So, there's no changing of minds at the end of it. Once a decision is made, then that is the resolution. However, the main disadvantage is that the resolution is taken out of the disputing party's hands, so they lose control over that final decision. And that could result in one or even both parties being unhappy with the final outcome. And that can harm relationships or impact negatively on job satisfaction and morale within the workplace. And it's also often the most expensive form of dispute resolution process. So, just to recap, disputes can occur in a business at any time and for a whole range of different reasons. And those that are over enterprise agreements can sometimes result in industrial action. And remember that industrial action, if it's approved by the Fair Work Commission, then it's deemed protected action. And if it's not approved by the Fair Work Commission, then it would be deemed unprotected industrial action and therefore unlawful. And to resolve disputes, businesses can firstly look to discuss or negotiate. However, if this does not resolve the dispute, then they can look to mediation, which is where the third party comes in to help facilitate the conversation between the two disputing parties. Or they could go further and use arbitration, where an independent third party actually makes a decision on the outcome. And keep in mind that our study design asks for dispute resolution processes such as mediation and arbitration. So they are the ones that are listed in our study design. So that brings us to the end of this video, which also brings us to the end of outcome 2. So congratulations on making it this far. I look forward to seeing you in the next video where we will begin the final outcome of Unit 3. But until then, just remember that for questions, activities, and help in your VCE journey, then come on over to teachingbubble.com.